Good evening, everybody. Hope you are all doing well tonight. This is August 6th of 2025. This is Jonathan Ginsberg coming to you live. As always, please tell me if you can hear me okay. You should be able to, but if you're not hearing me, let me know so I can adjust. I've got a couple of different microphone options here, but hopefully you can hear me. Obviously we're going to take a lot of questions and just a couple of things that I thought I would talk to you about a little bit, just so I kind of was driven home for me this week. Was actually kind of interesting. One was I had a hearing coming up next week. It was scheduled before a judge who was really, really difficult, one of the lower approval judges that I deal with. And I've dealt with this judge many, many times, and I really very low approval. It denies cases you should approve. And so I had a hearing coming up, and I was all ready to, present. I had my brief written and everything like that. I look online. I think it was Monday, and I see that the case is taken off the calendar and it's in decision writing process. So I called the hearing office. Lo and behold, the judge had agreed to decide my case and approve it on the record. I was floored. I mean, I never in a million years thought that would happen. My point is that this sort of thing does happen. If you've got all the evidence there, even judges who are, borderline unreasonable will still approve your case. And this is a judge who's about 25%, but the right cases he will approve. So, don't give up hope. And in fact, I did a video about this today, which I'll get out in the next few days. And that is that, what do you do if you're assigned a very low approval judge? And many people get very discouraged by that, but I'm here to tell you, I've won cases before judges with some of the lowest approval rates in the country. Not about me, it's about the case being a really strong case. So if you've got a good case, don't let the fact that the judge has a low approval rate dissuade you, especially if you're over 50 or 55. The ones those judges approve are typically people who are a little bit older. And again, the ones who have good medical evidence. In this case, I thought was a pretty good case. I was not expecting it on the record, but certainly I was not unhappy to get one. Second thing is, I was doing a pre-hearing today with a very, very nice gentleman who's got a hearing next week. And one of the issues that popped up was he's got some heart issues. He's on diuretics, which means on water pills. You may have heard of things like Lasix. There's other ones out there. And the problem with water pills is that when you take them, and again, this is very common in heart disease cases, it forces you to urinate very, very frequently. And I mean every 30, 45 minutes. And as I explained to him, I'm looking at everything through the lens of how medical problems or medication side effects would impact somebody in a work environment. And I will tell you from experience that vocational witnesses will say that if you've got to take an unscheduled break of 5 to 7 minutes every 30 to 45 minutes, that is an excessive amount being off task. And that's usually enough to convince a judge to approve your case. My point being that when you look at your case, when you think about how to prepare for the case, you want to think about everything through the lens of how does this problem affect me performing this job reliably? It's not about the diagnosis. You may have congestive heart failure. You may have herniated disc. You may have type 1 diabetes. The diagnosis does not win your case. What wins the case is if you can show specific issues that would make you unreliable. In this gentleman's case, going to the restroom, and we practiced testifying. How often do you go? And the first thing he said, well, I take the medication, and the first 3 hours I'm going to the bathroom 5 to 7 times, and then I take it after lunch, another 5 to 7. I said, no, that's not the way you want to explain it. You want to explain it is I'm on this medication several times a day, and on average, I'm using the restroom every 30 to 45 minutes or every 45 minutes to an hour, whatever the case is. And when I'm in the restroom, I'm in there for 5 to 7 minutes. Sometimes the urine flow doesn't start right away. Sometimes it takes longer to get things going. Sometimes I have, to clean things up. But the point is you want to give the judge a very clear picture of what is going on, what would stop you from being reliable at a job. And I realize every day is different. And again, you don't want to go to a hearing and talk about, well, some days this and some days that. Pick an average day. What I would say is an average to below average in terms of the way you feel, not the worst possible day, but not the best. So if it's on a 1 to 10 scale, 10 you're feeling great, 1 you're feeling rotten, 5 is in the middle. Pick a 3.5 to 4 and talk about or think about, write down what the specific issues that you're dealing with that would make you not reliable at a job on one of those days. And again, I realize every day is going to be a little bit different, but sort of pick an average. In the case of, a person who's having to use the restroom, again, every day is a little bit different, but, every 30 to 45 minutes, most of the time is sufficient. And that gives the judge a picture. You're trying to paint a picture of what's really going on. So I just thought that was very useful, the way I explained it to him, and just in that really think about this in terms of your work performance, because that's the lens you've got to think about this through. Social Security disability is very practical. The vocational witnesses there have knowledge about what employers will tolerate, especially in entry-level jobs. Realize as well that if you have a job that requires a probation period and you can't get to the probation period because of these issues that arise, that would make you unemployable. That would mean that you would not be able to sustain competitive employment, thus meet the qualifications for disability from Social Security. So that is the angle you need to really take a look at. All right, let's jump into some questions here. SA says, financially, I'm going to have to move out of state to a rural area with few doctors before being able to see specialists. My current state are unavailable till September, November, likely won't be here for those appointments. This will create a medical lag time I'm concerned about. Won't know any of these few doctors in a small town. Any advice? I'll be missing TMJD surgery in November. Was claiming TMJD for SSD. I had nothing for this condition in the new area. All right, so what SA is telling us is that because of financial reasons, he or she has to move out of a big city. Let's just take, for example, Chicago or New York or Los Angeles or Atlanta, and moving to someplace in the country where there's no specialists, there's not a lot of treatment available. And there's going to be a gap of treatment, because basically what we're going to go from is seeing specialists, orthopedist, neurosurgeon, kidney specialist, whatever, endocrinologist, to family doctors. Is that a problem? And yeah, it is a problem. I mean, I think that, Social Security, big picture, tends to think that lack of treatment or gaps in treatment reflect not needing to go to the doctor. So the problem is, if you're not able to go to the doctor, you can't meet the specialist, you can't undergo your surgery, then that's going to hurt your case. You got to really try to figure out a way, and there's no good answer to this, unfortunately, because if you don't have the money, you don't have the money. But you've got to figure out a way to get to doctors who can treat you, for specialists that will treat you for the underlying condition. And if that means making a special trip back to the city where you're from to get that surgery or to get that treatment, you kind of have to do that. If you don't, the risk you run is, and you can certainly tell the judge, the reason why I didn't have the surgery, the reason I'm not seeing specialists is I can't afford to live in, a big city. And the judge will say, I'm very sympathetic to that, but the absence of records means I don't have anything to go to base an approval on. So, there is no good answer to that other than to, use whatever resources you have, lean on family and friends to try to figure out a way to get to the doctor so that you can have a complete medical record, because gaps in treatment are a problem. Not seeing specialists are a problem. And, it takes a while sometimes to get a new doctor going. And, if you get to a hearing and there's an 8 or 9 month gap, and you haven't gone back to the doctor, it's a problem. Now, sometimes there may be a gap and then, you have a hearing a year later and you've resumed treatment. That's not as much of an issue, but yeah, this is a practical problem, and I wish I had a good answer for you, but I just don't. This is just one of the things where, because the process takes so long and because it's so unforgiving in terms of requiring you to go to the doctor, there's no really good answer to what you tell Social Security about why you're not going. Not being able to afford it is just not going to cut it, because they don't, hate to say they don't care, but they're going to say, well, what are we supposed to do? We're not going to approve you based on, what you think the doctor would have said to you. So SA, I wish I had better news for you, but that's the best I can offer. RB says, ALJ hearing pending is pending. Have a representative. A little worried my important files won't make it there. My recon denial contained docs I've never seen. It looked bogus. I can't seem to get clear answers. Well, simple thing would be your attorney should be able to get access to your file now, certainly at the time there's a hearing. So the first thing I would do is ask your attorney to download your file from what is called ERE, Electronic Records Express. It'll be one big PDF document. And if you have a PDF reader, which is going to be free, you can actually see what they've got. So there should be no surprises as far as the documents you have not seen that are mentioned in the recon. It may be, statements from non-examining doctors that Social Security had, or consultative doctors, or it could be, and I've seen this happen many times, a person with your name that not your records have got in the file, but you need to find out. Your attorney needs to find out. So I think the first thing is that is not hard. Get copies of what's in the record and look through it carefully. I think you should have a copy of your record anyway, because that's just important for your own personal medical history, medical file. But I would look to see what's there. And then, if there's other things that are not there, you need to have your attorney work with your attorney. And I will tell you that in the last couple of years, it has become a lot easier to get medical records. Up until a couple of years ago, we would have to literally request them by mail. We would have to struggle with trying to get them at no cost or low cost. It was a real problem. Now, most medical providers have portals where you can log into the portal and you can get the records there. A lot of them also were on the Health Information Technology system, where you can have the Social Security Administration get them for you. So getting records has become a lot easier. I've also had sometimes people will literally go to the doctor's office and say, I want my records. And most states say you have a right to get your records at little or no cost. There's a couple other ways to do it, but the way I use is I use a portal, or I use the Health Information Technology. So my point being, in 2025, it is much easier than it ever was to get medical records. And I think that, you should work with your attorney to make sure that he or she is using the portal access or using Health Information Technology to get them. Number two is that you should be able to get a copy of your entire claims file, the entire thing, well before the hearing, and you can look it over and read it, and you should read it. If you want to get real fancy about it, you could take that and plug it into an AI engine like Notebook LM or Chat GPT. I prefer the paid plans because they're going to be more private. If it's not paid, it's not going to be private. But you could ask, Chat or Notebook LM or Perplexity or Claude or any of these other AI engines, give me a summary of what's going on, and it will tell you. Or you could read through it. It may be 1,500 pages. You could read through it and see what's what. But, don't feel like you shouldn't be part of this process. You need to be part of the process. You know your health a lot better than your attorney, and certainly better than the judge. And if you see something missing, that's your attorney's job to get it. And so, there's something called the 5-day rule, which basically says that 5 business days before your hearing, which is going to be typically 7 calendar days or 8 calendar days if there's a federal holiday, or even more, your attorney has got to submit a 5-day letter saying, we know that these records are out here. We know that records from orthopedists, Resurgence Orthopedic, that they're there. We are trying to get them. We have made multiple efforts to get them. The portal is down, or we can't get them to provide them, and we're still looking, and please leave the record open. If you don't do that, the judge doesn't have to, but the judge may say, you didn't give me a 5-day letter, the records are not there. I'm going to make a decision based on what's here. Some judges are very hard line about that. Some judges are like, I want the full record. I'll leave it open. What do you need? How much time do you need? But, as an attorney, the last thing I want to do is to have a judge get upset with me because there's missing records that are important, because I think the judges struggle with, I want to give a fair decision, and I don't want to punish a client because the attorney didn't get the records or didn't give me a 5-day letter. So, these are some things you want to have a talk with about your attorney. So to summarize, get your attorney to give you the entire claims file, and it's going to be sections A, B, D, E, and F, with section F being the medical record. You want to look through all of it. Number two is if you have not set them up already, if there's any medical records that are not in that file, get your portal set up so that your lawyer can get them, or download the records and get them to your lawyer. Talk about the health information technology. Have a conversation with your lawyer or the paralegal, making sure that there's no questions, there's no debate about medical records that are outstanding. And the third thing would be ask your lawyer to make sure that there's a 5-day letter that is in the file if there's something missing, because you don't want to go to a hearing with something missing that could have been addressed at a using a 5-day letter or using the portal. So that's what I would tell you. And again, the biggest thing is just get a copy of your file. It is amazing when you read through it and read through it carefully, kind of what you see. And even in the A and B section, you'll see some summaries where the state agency many times did a summary, and they concluded obviously against you, but the summaries can be very helpful. And you want to get a sense of and talk to your lawyer about why did they deny you and what do you need to do to prove your case. And I find that very, very useful. So, talk to your attorney and learn as much as you can about your file. Cynthia with I. Hello, Cynthia. I hope you're doing well. And I appreciate you tuning in, as you do many times. I see you quite frequently, and I'm glad to see you today. Rodney, one of our longtime clients and live stream visitors. Good to see you, Rodney. I hope things are going well for you. Rodney is local here in the Atlanta area, and good to see him. Catherine, and I responded to you early before the live stream went on, is I got your evaluation. I have an intake specialist who kind of gathers information. Sometimes I'll call, but many times I have somebody else call just to gather information that I need. And I looked in the intake paperwork or the database we use, and it's got you, had you on for today. Maybe she didn't get to it, but we'll be on for tomorrow. I'll make sure you get called tomorrow. So I apologize for that, but that's what will happen. And again, thank you for tuning in. Let's see here. The Dreamers Club had my ALJ hearing this past Friday. The judge says my record was extensive. That's a good thing. Really nice, good thing. Toward the end, she asked for a CT scan. My pulmonologist referenced in his notes. She said as soon as she got that, she'd make her decision. She asked the VE3 questions. One with no limitations, which usually is just the state agency, which doesn't really mean anything. 2 is some mild, and last with all limitations and found no jobs in the last one. That is good. That is a good thing. And then I have severe emphysema, continuous oxygen, IBS, severe mental illness. Do you think asking for my CT is a good thing? It's a good thing. What you've got there, I think, is a judge who wants to make sure the record is complete. As I just said, there are times when something is missing, and it just slips through the cracks. I mean, it's going to happen. And some judges will say, well, there's enough here to make a decision, but given that you have emphysema as a major issue, the judge wants that CT so that when the judge writes a decision approving your case, which hopefully is what's going to happen, that will be addressed. Because realize, and this does happen sometimes, and if you remember Spencer Bishens from last week, I talked about this, the appeals counsel will periodically pull a file randomly to make sure the judge analyzed it correctly. It was an approval. It could be a denial, but typically it's an approval. They'll look at it and they will make sure that it's done correctly. And so not having a CT of the lungs when emphysema is your main issue might be something that would cause the appeals counsel to, on its own, send it back for another hearing. So what the judge is trying to do is avoid that. But that's what's going on. But I think you've got a really good judge. It looks like you said she was nice, which is great. And she wants to make sure she has a complete record. It looks like you're headed for an approval. And I think given your medical conditions, I know you've mentioned them before here, that's really a good thing. And speaking of Spencer, wasn't that a great live stream last week? Spencer was phenomenal, really high energy. And if you didn't see it, and I'll have him on again, Spencer is a former decision writer for Social Security. And what he did was he would get the tapes or the audio and the record file and the judge's notes, and he would actually write the decisions up using kind of a template. He talked about, that sometimes he would disagree with the judge and try to convince him to approve a case that the judge was going to deny. He said there's that freedom to do that with some judges. He also talked about that he felt that the complexity of the system, the difficulty you can have getting forms in or all the technical requirements are not unintentional, that they want to make it difficult for people to get on disability, and that you have to really be a very active and diligent claimant to get through some of the nonsense that's being thrown your way. But Spencer was great. I thought if you haven't had a chance to listen to it, look on the live stream on the YouTube channel, and Ginsberg SSD is my YouTube channel, and listen to it. It's well worth it. I mean, he was really, really interesting, and having somebody on the inside like that was really, really kind of cool. So I really appreciated what he did, and he's written a book, I think, about the disability process and kind of what you can do. You can get it on Amazon. Again, I linked it there, or you can go to Bishins Publishing, BISHINS, BishensPublishing.com, and you can order it there. And I've read it, and it's again, it's from an insider. It's really kind of cool. So I think you'll pick up some interesting things there, especially if you're doing this on your own, at least for the first part of it. It'll give you some insider tips. And of course, if you're watching this live stream, you see my videos, you're going to see a lot of things you can learn to put yourself a little bit ahead of the game to improve your chances at winning. Okay. Shauna. Okay. Yes. Okay. So we got a denial. I haven't seen it yet because the mail comes in, it's processed. I haven't seen that. We need to amend the onset date. Do we need to amend it moving backwards or moving forwards? So that's something I will make a note of, Shauna, and Jen or I will get a hold of you. I actually had an interesting, speaking of onset date, I had a situation where Social Security had approved a client of mine, but they changed the onset date. And I looked at the application, and the onset date was a year later than it should have been. And it appears to be our mistake. And I'll take, I didn't, somebody that my staff did it, but we're going to go ahead and appeal that. It was an administrative approval. We're going to appeal that, and we're going to ask that the onset date be moved back. My point here again is, make sure that when you're looking at the paperwork, and what happens, by the way, when you file an application, they will, and especially if an attorney does it for you, they will send you a printout of your application, and it will have all the dates on there, your date of birth, the date of onset. Look at that. And obviously we all missed it. And again, I'll take some responsibility for it because apparently I saw your intake form, this gentleman's intake form, and it was different than the date. It was a year later than the date that was put on the application. And again, somebody in the office did it, and they just made a mistake. And we're not perfect. We'll make mistakes. We can fix this one by appealing the approval, administrative approval, and then taking it back a year. So no harm, no foul. But my point is that when you do get these printouts, look at them very, very carefully. We should have caught it. My client should have caught it. But again, we can fix it. But that is an issue. So Shauna, I'm not sure if we want to amend the onset date to make it, later on so that you're older, or push it back a year or 6 months or whatever you want to do. We'll talk about that, but I'll make sure that Jen or I pull the file. I'm pretty clear tomorrow, so we'll make sure we take care of that. But thank you for tuning in. In fact, I'm going to put this on my little note sheet I always keep with me here. Onset. Okay, so I'll make sure that gets taken care of. Darren Magaha. My left knee is bone to bone, which sounds very painful. The right is arthritic. My right foot is arthritic. Many wrongly hear fractures from years ago. I'm 57, GED. When I qualify for a listing under 1.18, maybe. I will tell you, Darren, that the listings, orthopedic listings, listing 1, are extremely difficult to meet. And this is one of these areas where Social Security has gone, really to the extreme to really make it hard to win orthopedic cases, knee, back, elbow, things like that. And the reason for that is that the number one reason people file for disability is orthopedic, back, knee, and so forth. Now, my thought would be that what I would do when you argue is, you could certainly argue that you meet a listing, but the main thing that jumps to my mind is the grid rule. You're 57, all right, and if you have a GED, and it sounds like I'm guessing probably not a lot of transferable skills, if you look at the grid rules and go to gridrules.net, and you look at the sedentary grids, which is the 201 section, or the light grids, which is the 202 section, you very well may meet that. So again, at 57 with a GED, and let's assume no transferable skills, you look at grid rule 202.06, for example, and that basically says even if you could do light work, you are still disabled. And light work is defined as standing and walking 6 hours a day, lifting 10 pounds frequently, 20 pounds on occasion. I would bet that a person who's bone on bone with one knee and arthritis on the other one, right foot is a mess, wrongly healed fractures, you're not going to be on your feet for 6 hours. So that takes you out of light work. So you meet the grid. So again, I would argue when you apply, look at the listing, please evaluate this case under listing 1.18. Here's why. But more importantly, look at the grid rules. Look at 202.06, 201.06, I think. And I'm over 55, GED, no transferable skills. I meet the grid. And the third argument is your standard functional capacity argument, that the combined effect of your knee, your foot, pain, maybe pain medication side effects, maybe something else that's going on medically, the combined effect of all that would eliminate any type of job. So I think you've got all three theories of disability that would apply in your case. But more, I would not be too caught up in the listing. You put it in there, make the argument. I think the grid rule is probably a stronger argument. It's going to be easier. So I think that's what I would definitely look at. Okay. Sarah D. Have my hearing scheduled for the end of October, still not met with my attorney. Is that a red flag? Not necessarily. I mean, it just depends. I mean, sometimes, I'll get involved in a case early on because there's something that I want to really focus on. There are other cases where I get involved once in a meaningful way. And I'm always involved in everything behind the scenes, answering questions, so forth. But in terms of getting my brief ready, doing my pre-hearing, I may wait until the hearing is requested. It's getting a little bit closer because the file needs to be worked up. You realize when a Social Security has the file at the initial and recon, it's just a bunch of papers. Imagine a bunch of papers stuffed in a folder someplace, and it's not organized. There's no numbers on it. So there's not much you can really do to make, you can say, here's my date, but it's very hard to do much with that. When it gets to the hearing office, after about 2 or 3 months, sometimes it could be a little shorter than that, but let's say 2 months, the hearing office staff goes through, removes the duplicates, and assigns numbers like 5F, 6F to the medical record. At that point, when I'm looking at it, I'm looking at a document I can work with. I can work on my brief. And that's the point where I'm going to call my client and say, okay, here's what I'm seeing here. Let's talk about how we want to testify. I don't want to call them and do a pre-hearing 3 months in advance because they're going to forget. It's just not, it's too far in advance. I may call, but I got some of the question. I've got to know, I want to know the story here. Why did you stop working? Or, what was the issue going on? There's a gap of treatment. But in terms of the actual getting ready for a hearing, 2, 3, 4 weeks, is kind of my time frame. And, if I need to reach out to somebody beforehand, that's because there's something that I thought needed to be done. But I don't think if you have a hearing at the end of October that it would be too concerned that, you're not hearing from the attorney right now. Now, you should be hearing from the paralegals at least to make sure that the records are updated. As I talked about before, one thing I would do is I would ask the paralegal, case manager, or attorney, whoever you talk to there, is get me a PDF of the entire file. I want to look at everything. I think everybody should do that. So that's one thing I would do. I think the second thing is ask the person you're interacting with, the legal assistant, paralegal, whatever, do you have access to all the portals? Do you need me to get portal access for you for anything? Do you need me to, go get the records? You got to be an active participant. That is really more paralegal function as opposed to the attorney function. And then ask, when will I be talking to the attorney? And try to get a firm date on that. And realize, this is a practice area where, because the fees are set by Social Security and they're capped, we have to monitor our time. This is not where, if I was doing domestic relations, divorce work, somebody called me up, I'm billing that. Point 4, point 5, whatever it may be, and I'm sending a bill every 2 weeks or every month. Don't do that here. So, we have, because of contingency, we have to use staff people to help get the files put together. And the attorney time is really, what the attorney can bring to the party. People sometimes call me and I'll pick the phone up just because nobody else is, if I just see it, see the caller ID, it's one of my clients. What's the status of my case? That's really not a question for me because I don't deal with the day-to-day. I'm dealing with, getting the case ready for hearing, dealing with, I'm recording videos, I'm doing things like that, but status calls are really more paralegal functions. And it just depends on the size of the practice. We're not a very big practice, so, I may jump in and just pick up the phone and call somebody. If you're in a bigger practice, that's nothing bad about them, and there's 7 or 8 attorneys and there's, they're doing, hundreds of cases a month, it's going to be more difficult to get somebody. They're going to be more process driven. So we sort of try to strike a balance between being process driven and kind of giving that personal touch, but realizing that the time is of the essence and you got to monitor every minute. Rob says the judge asked only one hypothetical. If the hypothetical yielded the answer, there are no jobs, then yes, it's a really good sign. If the hypothetical yielded, an answer, or here are 3 example of jobs this person could do, that's not a very good sign because some judges will ask multiple hypotheticals. A lot of times the first one is just kind of a baseline, matches what the state agency found, and there will be jobs. Then there'll be another one and another one. And, I've had judges ask 5, 6, 7 hypotheticals. One of those represents what the judge believes is your residual functional capacity. The problem is you don't know which one. And of course, the attorney can ask a hypo, but, ultimately the judge is going to rely mostly on what, the judge comes up with. So if there's only one hypo and it yields a response of no jobs, that is usually a sign you've won. If it yields a response there are jobs, not as good. Dennis says being 57 will get CDR. Generally not. Spencer, we talked about this a little bit last week. In general, the CDRs are being done on people who are in their 30s, 20s, 30s, and 40s who are going to be drawing on the system for the next 15, 20, 30 years. When you're 57, you're getting close to retirement age. So, you're not the person that they're looking to, to get off the, the system. So I think that, you're not the person that they're looking to get. Realize at 57, you have the grid rules that apply. You have, the fact that there's an inherent bias in Social Security in favor of people who are over 55. So, it's a lot harder for Social Security to deny somebody over 55. Similarly, it's harder for them to do a CDR and move to terminate. Now, there are some random CDRs. It's just the system will kick them out periodically. And the other thing that will trigger a CDR is if you're working and they start to see earnings on a regular basis, or there's some evidence that you've improved, your condition has improved. That could be that the medical that ultimately got you approved is one where, let's say you had a back problem and you were approved in April of 2025 and you told the judge that I'm undergoing surgery in September of 25. The judge may put in his notes, this case is to be reviewed in, July or August of 2026 because we want to see if the surgery was successful. That could happen. If it's mental health, sometimes judges feel like once the medications get you stabilized, then that may be a reason why they would do a CDR. So it just really depends on the situation. But generally speaking, a 57-year-old is not the target for a CDR. Trish, how you doing, Trish? Hope you're doing well. Vince, how are you doing? Vince is one of my clients. How are you doing, Vince? Good to see you. How are you doing? And I'm not going to say your name unless you want me to. One of my clients, how are you doing there? Tara, one of my former clients, good to see you there. My pleasure. How long in Georgia does ALJ make a decision after a hearing? It just kind of depends on a couple of things. I mean, I'm literally seeing decisions now. I tried some cases in July, let's say the first week in July, I got decisions the last week in July, and the money has already come through. So I've had situations where we get a decision and my client gets payment all within 30 days. I've got other ones where the decision writing process is 6 weeks and pending. It just depends. So, and there's no correlation between the amount of time it takes for a decision to be written and whether you win or lose. It just comes, in fact, what Spencer has told me is that favorable decisions take more time than unfavorables, because a favorable, the judge has to justify putting Social Security on the line for payments. So they've got to be even more careful. Again, doesn't mean that a long delay means you're going to win. It just means that, there's a backlog in the particular office or the writing office case that's assigned to your case. But I would tell you, in Georgia, I'm seeing them, and I'm in Georgia, so I have a certain percentage of cases here. You know, within a month is pretty typical, but you can't, I don't want to give you an absolute on that. Tom, is it normal? I haven't spoken to my attorney, update the history of my case? Not at all. Again, I think this is one where if it's in the middle of the case, you're at recon and you're just providing general updates, the attorney is not the one who's going to be downloading medical records and uploading them to Social Security. That's a paralegal function. And, there are times when people want to talk to their attorney just to get an overall strategy. Fine. And people will call me and I'll call them about that. But, if somebody is calling me every week, they only want to talk to me to get the status of their case. That's not going to really work with us because, again, I'm not the right person for that. And, like I said, I like to be straight with everybody, very, very transparent. Social Security disability, in order to make this a viable practice, you've got to delegate to staff people that can do things. That's what their job is: processing the mail, downloading medical records, updating them to Social Security. We have a system where we on every email that we send out, we link to a little form. Have you gone to a new doctor, got to new medications? And these come in on a daily basis. My paralegal, Jen, who's here sometimes, or one of her people, will get that information, create either a fax or an email to the adjudicator and say, here's more information. I'm not involved in that process at all. I designed it, but I'm not involved in it because I wouldn't get anything done if I'm processing paper. And so, again, I think that if you want to talk to your attorney kind of big picture, this is before you're at the hearing stage, I think that's reasonable. Not every week though, because it's just, there's no way that can really work. And, look, every practice is different. There are some lawyers who, are going to be willing to talk to people, their clients, and do all the work themselves. They do 4 or 5 cases a month. And that's, if you need that kind of hand-holding, more power to you. Most firms are not going to do that, but there may be some that do. And so if that's what you need, I think it's important for you to make that clear to your attorney at the outset, and for your attorney to make clear to you what the reasonable expectations are, because everybody needs to be happy. And my feeling is, my focus is one thing, that is to win the case. And so anything that takes my attention away from getting my cases ready is a distraction. And so I don't want to be involved in, downloading medical records. That's not going to help me prepare cases. What helps me is to review the record, to really think about what I want to argue, to prepare my clients for hearings, and to get ready to win. Nickerson Mencio. Hello, Nickerson. Hope you're doing well. St. Louis Grand. Can a person add documents to the like to their file after initial claim was denied, outside of adding docs with an appeal filing? I'm not sure exactly what you're asking, but generally speaking, you can add documents to a file through the administrative law judge hearing. At the appeals council, I don't want to speak to that, but I don't know that you're going to be, I think the appeals council is dealing with the record as it was at the time of the hearing, unless, I believe there are some instances where if there's records that existed that were not obtained, that may be something that they might be interested in. I don't want to give you wrong information. I don't, typically I co-counsel with somebody on appeals counsel work, but generally when you get beyond the hearing stage, the appeals council district court is working with a record that is closed. And I think there may be special exceptions for getting something new in, but I would defer to, somebody like Brian Konoski or Carl Osterhout. That's who I would ask about that sort of thing, because they know that they deal with that all the time. Okay, I'd like to thank Team Ginsberg. Got approved in July. Didn't expect to be approved that quick. 61 with the usual problems working part-time. Can I still work part-time? Yes, you absolutely can. I'm glad we got you approved. And you can work part-time. And just to give you kind of a big picture overview, and we try to do this in a written form, a video form. There are two things you got to be careful about. We're going to think about. One is that you have 9 trial work period months after certainly after you're approved, and you can use sometimes before you're approved, but let's just assume you haven't used them up entirely. And the trial work period month is a figure, I think. Let me just see what it is here. Trial work period. I should have these committed to memory, but I don't. All right, it's $1,160 in 2025. So if you work and you earn $10,000 in a month, okay, that does not affect your benefits because you've used up only one of your trial work period months. What is it? I said $1,160. So if you earn less than $1,160 ongoing, not a problem. You're not even touching your trial work, but you have 9 of those to earn more than that. Once you use up your trial work period months, and you've got to keep track of it yourself, there's no online repository for this information, then you got to worry about not going over SGA. And SGA, or substantial gainful activity, it changes every year. $1,360 per month gross earnings in a calendar month in 2025. So if you stay below that, you're always going to be good. But again, be aware of your trial work period months, because that would allow you theoretically to go over SGA without any sort of problem. So yes, you can work part-time, but you want to just keep really good track of when you receive those earnings. And by the way, for purposes of counting earnings, it's the month you get the payment. So if you worked in July and you got paid in August, that counts towards August. If you're paid bi-weekly, there's going to be a couple months you have 3 pay periods. That may take you over SGA. If you have trial work period, not a problem. In the trial work period, you have filed 5 trial work period months in any, 9 trial work period months in any 5-year period of time. So it's a little confusing. I've got some videos on it. But just, that's what you have to be careful about, is to not earn too much money. What you don't want to do is earn enough money to take you over SGA, over trial work period, but more importantly over SGA, but not enough to pay the bills. The second thing is that Social Security may not catch that very early, maybe a couple of years. And what you don't want to have happen is in 2027 to get a letter from Social Security saying, by the way, we see that you were overpaid by $30,000. Here's an envelope, pay it back in the next 10 days. And you can discharge it in bankruptcy, but that's what you got to be careful about. So you really, really want to be just very, very careful about that sort of thing. It's about the trial work period. And if you don't understand it, call the office. We'll schedule a time and I'll go over it with you and just kind of walk you through the actual figures. Lulu, my attorney advised me very strongly to appeal the onset date. So obviously either you got approved early or at the administrative stage or at a hearing, but a different onset date. You said you don't want to. You want to put this behind you. It was so stressful. How her name still appear in the SSL portal. Generally, I wouldn't worry about that too much. I mean, again, if you make it clear to your attorney, you don't want to appeal the onset date, the attorney should not be appealing anything. A lot of times they leave your name on there, and unless the attorney formally withdraws, it's kind of funny the way it works. I still get email or letters from clients I represented 15 or 20 years ago because my name is associated with the file. And it's, it could be a change in, the yearly change in payment because of cost of living or, any number of things. It could be just notices. So I wouldn't worry about that too much. But if you've made it clear, you don't want to, you don't want to appeal the onset date, you definitely don't want to see an appeal there. And you want to make sure you put in writing to your attorney, I understand why you want to do it, but I don't want to do it. Although, again, hear your attorney out, because I will tell you that, this is something I'm seeing more and more. They're approving cases, but they're changing the onset date to cut out past due benefits. A lot of times it's very arbitrary. They just pick your 55th birthday, and it just doesn't make any sense. I have a hearing coming up next week, in fact, where my client got approved at his 55th birthday. I'm looking at the record, and from 52 to 55, he was in much worse shape than he was after 55. They just arbitrarily chose his 55th birthday, but it made no sense. So we're appealing it. My thought said to him was, look, there's always the risk you get a bad judge. We happen to get a good one, but there's always a risk you get an outlier judge, always the risk that something happens, you get denied, because the whole hearing, the whole issue, the whole case is now at issue. But if they approved you early on, at 55, it's generally speaking, the worst that's going to happen is the judge would, just keep that and approve you again at 55. But in my client's case, I feel like we've got a really strong argument that he was such a mess before then that we can get that earlier onset date. Every time I've done it so far, and I don't want to jinx myself, we've not had any denials. It's all been, I think maybe once or twice they kept the original onset date, but the other cases they went with the earlier onset date. Can a person just send DDS OHO evidence documents out of the blue without being part of an appeal after the initial filing? You can. There's nothing that says you can't. But do you want this document in your file? Is there any value, any reason for that? If you're at initial and you want them, if you're not represented and you want them to get it, every medical record is supposed to be in there. If you are represented, I wouldn't send anything without talking to your lawyer, because what you may be sending in could do more harm than good. But if it's just something, it's a test result, if it's a prescription or something like that, you could certainly send it in. But you need to make sure that you have the right barcode so it gets associated with your file. But yeah, there's nothing you can't do that. It's just, I would say this: everything you send to Social Security, there should be a purpose behind it. There should be a reason you're sending it to them. Sending them random information is not going to make any difference. But if you send them something that is relevant to your case and to your argument, that's what you want to be doing. Okay. Finally got my SSDI. Didn't even talk to anyone, getting everything worked out now with the medical final approved Friday. Yet to hear anything from Osterhout. Thanks for your help, though. I appreciate. Let's see the rest of it here. I don't see the rest of it here. Okay, well, the bottom line is you got your SSDI. That's what's important. Everything else is secondary. If you win and you get your benefit, that's what you want. Russell, what if you worked at a gas station because of the constant turning around, massively increasing pain and doing more damage to the spine? Being a single father, I have not been to a doctor. But ended up in emergency room, got MRI with a lot worse before the imaging. I'm at the point now it's really hard to work to get the doctor because of having no insurance. Okay, so I get what you're getting at, Russell. So what Russell's asking here is single dad. He's working at a physical job at a gas station. There's obviously some twisting and turning, which is a problem. You don't say how old you are, but the question ultimately comes down to is, I can't really afford to stop working, but I'm truly disabled and I can't really afford to go to the doctor, but the MRI and the emergency room would support my argument. So, look, in a back pain case, an MRI is kind of the gold standard. And if it shows significant damage, judges will assume that you've got, if you have two herniated discs and you've got, nerve compression and radiating pain into your legs, I think most judges will assume there's a connection between those two things. It is certainly better to have ongoing treatment, whether it's physical therapy or pain meds or even a surgical consult. So you have an incomplete record. You do have some evidence that shows there's something there, probably not enough to satisfy Social Security. If you stop working, because the record is somewhat incomplete, not likely to get approved early. Again, all assuming that the MRI is not showing just like complete disaster back there. So, if you apply with an incomplete record, you're going to get denied. They'll send you to one of their doctors. Maybe that helps, maybe it doesn't. I wouldn't want to be in a hearing where, only thing I've got is an MRI report and an emergency room report. I think that you've got to get to a doctor. And I realize that financially is a problem. I realize that stopping work would be a problem. These are just insolvable problems. You can't be working when you're applying for disability because they define disability in terms of not being able to work. So if you're earning more than SGA, again, this $1,360, by definition, you're working. So it's a real problem. Although my sense is that they're, again, depending on your age, if you're over 55 or over 50, and I don't know that you are, your case is even stronger, but even under 50, bad herniated disc, you can make a pretty good argument that there's no way you could be reliable at any kind of job, but again, an incomplete record. So it's going to be hard to win with just that. Naomi Cruz. May 29th, I had a hearing that was on remand from federal court. This time I've not received news of the decision. Judge wants a second hearing before her final decision. So what's going on here is you had a hearing, you won your remand, which is good, had a hearing, the judge wants another hearing, and there's obviously a reason for that, probably wants to bring a medical expert in. As I mentioned before here, some judges, if they get a remand, they're very, okay, I've been slapped down. I'm not going to play around with this. I'm going to go ahead and approve it. Other judges, like, I don't give a flying, what about what the appeals council or federal court did. I'm going to make a decision based on the evidence here. So it just depends on the judge. But obviously the remand will have an order in there saying the judge is to do this. And so you want to make sure the judge does that. And you want to have all the evidence that you can, but your attorney may be cross-examining a medical expert. Why does SSA, Cecilia, send you for a medical physical exam and then totally disregard what their findings are? Well, the consultative evaluations physically are mostly kind of useless. I mean, they're basically, doctors, many of them are, I sort of have a derogatory term for it. It's sort of a strip center doctor. These are not necessarily the cream of the crop, not always, but, many times these are doctors that do consulting work. They work for insurance companies. They review claims, and they're just making extra money. They're paying off student loans. And sometimes it's just, they didn't get picked up by the expensive practices, so they're struggling financially. They've got hundreds of thousands of dollars of student loans, and this is what they do. Many of these consultative evaluations are 15 minutes. Many times they use the same format. I look at them, obviously, in preparing the case, but I don't put a lot of weight into them because I don't know that a medical doctor who sees you for 30 minutes without the record and simply to evaluate you for functional capacity has the tools to be able to do that. And I think many judges see it as a big waste of time. The reason why they have it in there is that Social Security has the obligation to develop a record. And the consultative evaluations are how they do that. And so, more and more I'm seeing cases where adjudicators don't send people out for these because it does cost Social Security money if you have a good record, but it's not unusual for them to ignore it because it's worth ignoring. There's nothing valuable in it at all. Okay, glutenless Sin City got my SSD. Great. That is great. You're welcome. Very, very welcome. Thank you for Sarah. Thank you for tuning in. I appreciate that very much. The disciple who Diogenes loved. That's an interesting handle. If an ALJ denies a second remand hearing and noted uses estrogen patches in a long paragraph, which has nothing to do with disability claim, is that an issue? What you're getting at is a mistake. Well, you're not saying that it's not true. And again, I don't know, whatever reason you have for using estrogen patches is your reason for doing them. If it doesn't negatively affect the decision, it's not harmful error. If the judge, put that in there and you were not using those, and he relied on hormonal issues as a reason why you're having symptoms as opposed to orthopedic issues, that would be grounds for appeal. If the judge said, and I've seen this happen a few times, the judge will say the claimant reports that, severe pain in the right arm. In fact, it was the left arm. That could be a big deal because if the person's left-handed or right-handed, it may or may not be a reversible error. But again, if the judge got let's say that you're right-handed and the judge was kept talking about the left arm when in fact it was the right arm that had, significant problems, and your right hand dominant, making that mistake would be, I think, reversible error. So it's just going to depend on the context of that statement, whether there's any truth to it at all, whether it had any bearing on the decision at all. That's something that your attorney or, in my case, what I would use is there's appellate attorneys that I run these things by, and we'll say, okay, here's a mistake. The person, the judge put in there that this person was on, oxycodone when in fact it was hydrocodone. Probably not reversible error because it's not going to make much of a difference. But if the judge put that the person's not taking any narcotic pain medications when in fact there is evidence they were on, morphine, that is a reversible error. So it's just going to depend. It's really going to depend on it. I have a great spine surgery journey. I have a great workers' comp lawyer who does SSDI. Excellent. I mean, my case, I have my wife who's a comp lawyer in Georgia here, and she's really, really good. I don't want to mess with her. I don't want to mess with her. We don't share a lot of cases because, Social Security and workers' comp don't play well together, but we certainly had a few that we've worked on together. And it's good to have both if you've got an active workers' comp case. RD says hello from California. Hello, RD. Thank you. You're welcome. You're welcome. Okay, this is a interesting question. Disciple who Diogenes loves says, what do you think of an ALJ that says the medical record is inconsistent about the client not being able to interact with others? That's a vocational factor, not being able to interact with others. But the evidence says you go grocery shopping and visit the dentist. So what the ALJ is really saying is for a person who doesn't like to interact with others, going grocery shopping, going to the dentist. Going to the dentist seems to be a little bit of a stretch because you may have to go to the dentist for medical reasons. But let's say going grocery shopping, taking a walk in the park, these are things that are not consistent with a person who needs to avoid crowds, needs to avoid the general public. So it just depends on, if you're saying that, I get very freaked out, I have PTSD, I get really freaked out being around other people, I don't like to go into restaurants, I'm, hyper vigilant, that sort of thing. Yet you go grocery shopping, right? You go to the movies. Not really consistent. Now, maybe you can explain that when you go to the grocery store, you do it at 10 o'clock in the morning when there's nobody there, you have somebody with you. There may be explanations behind it, but big picture that, activities can be inconsistent and judges rely on that to deny claims. Interview with Spencer, and if you haven't seen it, really, really good. I think it was one of the best interviews I've done. I've got more people coming up later this year, so we'll see more, and we'll see Spencer again, I'm sure. How does it affect your chances when you have to fire a doctor over failure to respect your wishes? I did just that a month ago when I found a disc in my neck bulging at C6-7. I have numbness in my left arm from the disc. I was also a diesel mechanic for decades. Hands are also an issue. My arms, they suggested a mental health evaluation. I disagree with them where to go, so I fired them on the spot. I would say this, Bill. There are instances where you may not agree with the doctor's approach. You may not agree with, the way the doctor's treatment of you, may be disrespectful to you, whatever the case may be. That's part of your record. If the doctor puts in the record that you are, drug seeking or have secondary gain or exaggerating, that would be something you want to directly rebut. If it's because, the doctor said you may want to, maybe the doctor said he feels there's a psychological component to your pain, and you found that offensive. Okay. Um, I don't know that that's really a problem. I mean, as long as you continue to go to the doctor. I would tell you in general, if a doctor suggests something that's not, beyond the pale, don't dismiss it out of hand. Um, there's nothing wrong with having a psychological component to uh, pain syndrome. It can be very, very depressing to be under a lot of pain. Um, but again, if you don't want to go that route, that's fine, but you should find another doctor. But I think that, leaving a doctor because you felt that there was a misunderstanding or there was a lack of communication, that does happen. And assuming the doctor is not going to try to undermine your case, you just get another doctor. Who got the books? There are two people who got them. I don't remember the names, but they actually weren't books. It was audio. Two people got the audio. They got, well, I think first question was, where was I a couple weeks ago? I was in Traverse City, Michigan. The second question was, I think, what type of dog is Sadie? Or maybe I think I said, what was the type of dog? And she's a golden doodle. So somebody emailed in and got the answers, but that was it. The Spencer's, it was great. It was really, really good. You bring on stellar guests. I mean, Adriana, Brian, Spencer, can't wait for your retired ALJ. Yeah, I got to get him on. I haven't talked to him in a while. I need to get him in the loop. In fact, I'm glad you reminded me of doing that. I'll reach out to him. He said he would come, and I just, dropped the ball a little bit. I got really busy and hadn't followed up with him in a while. He and I used to kind of communicate by email a little more often than we do now, but I will reach out to him. Chan Tet, 49 and a half years old, working after submitting file for my appeal. How many days for expecting to hear? After an appeal, if it's, let's say, a recon appeal, it could be 6, 8, 10 months. I mean, it's not a fast process. So that's what I would tell you is don't, after 4 or 5 months, that's when I would reach out to your congressperson, your senator. But nowadays, with the shortage of staff they've got, this is now taking, 8, 9, 10 months. Chill mode, no question, just stopping by to say thanks. I'm very, very glad to see you. Actually, I wanted to show you all something. I found this. I mentioned this before, and I've been kind of, let me see if I can show you here. Sometimes I try to explain to people what it means to be disabled and what the standard has to be. And so this is a pretty good example of what it needs to be like. Let me share this. And here is an example of what I mean when I talk about doing any kind of work at all. All right. I found this on Facebook. And here's a guy sitting there and he's looking at things coming down the assembly line and he's on his phone and he's just checking to make sure that, the assembly, if things are coming down the assembly line. This is a job that for Social Security purposes, they're going to look at this and say, if you can fog a mirror, you can do this job. And all you need to do is just physically be alive to do this job. Now, a job like this, you can't take unscheduled breaks to go to the bathroom 3 times an hour. If you're off task more than 10 to 15% of the day, that's going to be a problem. If you're missing more than 1 day work a month, they can find any number of people who can do this job. But, a lot of people they talk about, well, can I go back to my past work? And the issue here is, it's not your past work, it's a job like that. So that was a video I found, but that's an example of the world's easiest job, or one of the world's easiest job. You can do it sitting or standing. Good for this gentleman. Somebody's paying him to do this. But that is what I mean when I talk about a simple entry-level job. And this is, again, just to if you focus on this, if you're under 50, that is the level of impairment you got to have, that you couldn't do this job. All right. So you see, I mean, this doesn't take very much, but you got to be reliable and you've got to be able to stay at the workstation and not miss too many days of work a month. But beyond that, you have to have a pulse to do this kind of job. And there are a number of these sit-stand unskilled jobs out there, this is one of them. But I just wanted you to get a sense of visually what I'm talking about when I talk about not being able to do anything at all. If you're under 50, when you're over 50, you have the grid rules where you can still have some capacity and more than this and still be disabled. But under 50, this is what you got to prove. All right. Dad says, has Doge focused on older recipients? No, not that I'm seeing. I think that whole Doge thing was kind of a storm of activity, and Elon Musk has moved on. We have a commissioner. He's being sort of tied up by, people like Elizabeth Warren, is a senator from the Northeast someplace, trying to deal with the phone issues. There's a problem with getting people, answering the phones, the wait times. Commissioner Bisignano is being kind of hit on all sides about that sort of stuff. He's trying to say that Social Security is responsive, and they're responding to people, and they're there when you come in. And so he hadn't had time to really focus on trying to deal with more of these CDRs. So no, the answer to your question is no. Constitutional immunity. Hello from Punta Gorda, Florida. Hello. I've never been there, but I'm sure it's very nice. Going to be in the 30A area in a few weeks. It's called Seaside. If you've ever been down there, not too far, Fort Walton Beach, and you're not too far from Panama City. We go as a family. My wife, myself, my son, my daughter, son-in-law, granddaughter. We all go rent a house for a week and just kind of hang at the beach and eat too much and play a lot of tennis. So I usually do the live stream from there because I'll have internet connection, so it won't stop me from doing it. But we're going to go in a few weeks. So, even though I'm in Georgia, it's pretty hot. We're going where it's hotter in Florida. I was talking to a client today in Miami. He said it's really, really hot down there. This is on the Panhandle. It's not too bad. And then October, I'm going to go back with my friend, a couple of friends of mine. We have a tennis group that we go down there to Miramar Beach, Florida in October for sort of a tennis weekend, guys tennis weekend. And that's kind of fun. So, try to get down there, try to enjoy a little time. And because everything is done virtually, I've tried cases from down there. I'll just, if I have a hearing, try to get it ahead of time, prep it, and then just do the hearing. And I've done enough of these where I just do them. Okay, this is a person who the judge wanted to see a CT scan. Is going to cause huge delay? No, not really. I mean, the judge is holding it open for that. Once the CT scan comes in, and I wouldn't send in the actual scan, I would send in a report. But the judge will look at it. It won't. My guess is the judge probably has it teed up. We played a little tennis today, as a matter of fact. Probably teed up for an approval. Waiting for the CT, and assuming the CT says that the emphysema is still there, it's just going to get approved. So I don't think it's going to cause much delay. Jeff says, I've applied before and lost before a judge. If I apply again, will absolutely go before the judge. Probably. My experience has been if you reapply after a denial, the odds of getting approved administratively at recon or initial, not really great. Now, maybe something significant has changed. You have a new medical problem. You've changed age categories. So it's not impossible to get approved. But many times, if you've been denied at a hearing, it's going to prompt the adjudicator to be more likely to just go ahead and deny it again. So you go to another hearing, probably the same judge. So you really want to focus on what has changed. And in fact, what I do is I look at that unfavorable decision. Why did the judge turn me down? And then, what is different? How do I get past that? And that's really what you want to talk about with your attorney, because you've already been denied once by the judge. What has changed? Because the judge or another judge for that matter is going to look at the unfavorable and say, okay, well, we denied him before. What has changed? And so you want to be prepared to answer that question. Does every person face a judge after their exam? Not every person, but I mean, statistically, initial is about 35% cases are approved, which means 65% are denied. Of the ones denied who file an appeal, not everybody files an appeal, but the ones that file an appeal, request for reconsideration, it's about 15% of those that are approved. So it's pretty low. And then of the 85% of the people that don't get approved at recon, they request a hearing, about half of those get approved at a hearing. So the odds are if you got denied at a prior hearing, you're going to go in front of the judge for another hearing. Not absolutely, and you can certainly, if you've got something that's changed, make that argument, but I think that my experience has been it's probably likely to be. Juan, thanks for the information. You're welcome, Juan. Nickerson, hello. Russell, I think Russell, this is a great question. No one's ever asked this before. This is a really smart question. Thank you for asking it. So if you have a video hearing on Zoom and, let's see, your client's on Zoom and needs to ask you a question on what's happening in court, the judge will allow you to go to the side room anytime a question is asked of you. Generally, no. Now, the one exception to that is if the judge makes an offer to change the onset date and approve it. Let's say the judge says, okay, your onset date was age 53. I'm willing to grant this case at 55. Do you want to talk to your client about it? Now, I probably have already done so, but if not, that would be a situation where the judge would go offline. I would talk to my client. Now, in that case, I would probably put everything on mute and then I would call my client as opposed to doing it by Zoom. Many judges will say, if you need to take a break, let me know. I have not ever had a judge say, if you need to take a break to talk to your lawyer, let me know. So generally speaking, other than to talk about a onset date change, you're not going to be able to go into a side room and talk to your lawyer. This is not, one of those kind of cases where they let you do that. Now, I suppose if you had a really significant question, but of course the problem is how will my client get that information to me? But if for some reason my client said, there's I don't know, I'm just thinking out loud, I've really got to go to the bathroom, or I said something before that is incorrect, what do I need to do about it? That may be a situation where I may say to the judge, my client has just messaged me that he inadvertently said something that was incorrect. He would like to correct that. May I speak with him for a minute to just see what this is all about? Judge could say yes, judge could say no. But generally speaking, they're not going to give you a chance to sort of go off on the side to talk to on a recess. The hearings last 45 minutes, and judges are going to get probably a little upset if you ask to do that, other than the time to talk about changed onset date. Who should request my FMLA file from my previous employer, myself or the paralegal? I don't think it matters. If you're, answer your questions, that's a paralegal job. That's why you're paying a lawyer. I'll let them do it. But if they're having trouble getting it and you can get it easy, the more important thing is to get it. But, I let the paralegal start. That's their job. So, yeah. When does your Medicare kick in? 2 years or the 25th month after you're first paid. So if you're paid, again, assuming you're not retirement age, Shub, if your first payment is May of 25, June of 27 is where Medicare is going to kick in. It's the 25th month after you're approved, the first approval. So you don't count it's not the date of onset because you don't count the waiting period. The waiting period does not count in this calculation. After the waiting period, first payment awarded, not the past due payment, not just the first ongoing payment, but the first month you're eligible for payments that made up that lump sum. If that was May of 25, then June of 27. Okay, this new SSR 24.3P, effective January 6, changes how vocational witnesses testify. Instead of specific occupations, this shift replaces another ruling, which require clear identification of jobs and rely on the DOT. Okay, what do I think of this? All right, this is a very interesting question. What he's talking about is there is a new ruling that came down. And I think your numbers are right, but I'm not going to go take time to look it up. But basically what it talked about was the vocational witness testimony. And what prompted all this is that the DOT, or Dictionary of Occupational Titles, is a publication that describes every job that exists in the economy. The problem is it was last updated in the 1990s, some of the time in the 1980s. It's way outdated. So up until the first of this year, vocational witnesses would testify about what the DOT said. And, there are jobs in the DOT like typewriter repair person, or, microfilm worker, or, photocopy machine operator, that just don't exist anymore. And over the years, Social Security has released these emergency messages. They call them EMs, emergency, you want to look them up, where they basically say that judges and vocational witnesses are no longer to consider these jobs. They're obsolete. But that's a Band-Aid on the problem, and that is the DOT is outdated. So what the ruling says is that the vocational witness has to explain where his or her data comes from. And, the DOT is still there. The problem is that the new sources of information, and a lot of them use a program called Job Browser Pro, and they look at these, they call them SOC codes, special occupational characteristics. And the problem is they don't line up with the DOT. So when the judge says, can you identify jobs, the vocational witness will identify jobs from the DOT. A job, let's say a cashier 2, whatever that is, 234.678-010, light semi-skilled. I'm just making that up. The problem is you've got to show, Social Security's got to show that these jobs exist in sufficient number in the economy. And what we find is that there may be in any one of these, SOC codes or these other type of codes, there may be 10 DOT jobs. And so you can't assume that divide the number from the later resource by 10 to get the number of actual jobs. The reality is we don't know. There's no definitive information about how many copy machine repair people jobs there are in the economy. Vocational witnesses can estimate it, but they're estimating based on really incomplete records. So what's happened is, it's a very long way around this, but what's happened is that judges now ask vocational witnesses to identify the sources of where they came from, of their testimony. And they'll talk about, Job Browser Pro, they'll talk about they reviewed this and the DOT, this, that, and the other. And it's all a bunch of BS because it's not accurate. The problem is, so, as an attorney, I have the right to cross-examine the VE on methodology and sources. The problem is, and if you don't do that, by the way, you can't later on in appeal come in and say the VE testimony should be disregarded because it's based on flawed information. The problem is to do an effective cross-examination of a VE might take 20 or 30 minutes. And, you get into the weeds, and some VEs are very defensive about it, but it could take 20 or 30 minutes. These hearings are designed to last 45 minutes. And my experience is judges get a little PO'd when you start going into exhaustive detail about the VE testimony. But on the other hand, there's case law. In fact, I just saw Adriana talked about a case that she reviewed, that if you don't do this, you're waiving your rights. So you're between a rock and a hard place. On one hand, you've got inherently flawed data. On the second hand, you could certainly cross-examine a VE to essentially prove that the data that the conclusions they're drawing are based on flawed data. You have case law that says that Social Security doesn't really care that that the data is not flawed. They're going to let the VE use experience and knowledge to be sufficient. But if you wanted to do that, you got to spend 30 minutes doing it. It's a mess. It's really kind of a mess at this point. And I've kind of come down, and I know there's some attorneys who will take the position, I'm going to do an aggressive cross-examination of the VE. And I've cross-examined VEs. But my feeling is I want to win. Okay, I'm not trying to make law here. And I think it's kind of like you're rearranging deck chairs on the Titanic. Yes, could you win on a technicality that the VE testimony is based on flawed information? Perhaps. So what ends up happening is you get back to another hearing where the same thing happens. And again, Social Security's made it clear that A, they recognize the DOT is outdated, and B, they recognize that there's no definitive way to know how many jobs exist, but C, they're going to let VEs testify about job numbers anyway. That's just the reality. So my opinion is I don't take a hostile approach to VEs unless it's absolutely necessary, because it's not going to make a difference. And I just realized that, okay, I may be waiving, some rights to cross-examine a VE, but I can still come back to, if I'm focused on cross-examining a VE, look, there are thousands of jobs out there. So if VE comes up with 3 or 4 and you can cross-examine the VE and say the numbers are not correct, they'll come up with another 3 or 4, another 10. And at some point you're chasing your tail, because if a person, has some capacity to work and VE gives representative sample of 3 jobs, there's 30 more out there. Now, if the VE says there's only 2 jobs I can identify based on this hypothetical, different story, because now I can say, well, let's look and figure out, do these 2 jobs really exist in sufficient numbers? But that's pretty rare. So a long way around is that, a lot of people are using this new ruling as grounds to appeal cases, to cross-examine VEs. I don't know that it really serves a huge purpose, other than to kind of delay the inevitable, and maybe you get another hearing, but it's going to be 5, 6, 7 years. I just want to win early. So I'm not looking for cases where I'm trying to pick a fight with the VE. And if a judge wants to deny a case, he'll find a way to deny a case. Okay, so I realize that's a long answer to a short question, but it's a philosophical question as to what you want to do, and it really depends. There are rare circumstances where I'll take the aggressive approach. Usually, I'm, going to really focus more on the impairments and winning my case, as opposed to trying to, cross-examine a VE with an impatient judge sitting there. Do I know SSD attorney James Brown? Brent, I do not know him. May have semi-retired, sold his practice. Okay, well, you know what? If you want to email me, SSD Answers 123. I maybe have heard that name. And just if anything you can tell me about James Brown, he may have been on. You know what? I'm not mistaken. Brian Terrian may have had James Brown on his podcast or his video at one point. Brian is a non-attorney rep I've known for years and years. He used to sell my book, and every once in a while he'll call me and ask me to try, to handle a hearing for him. Nice guy, and I know he's interviewed other people, and if I'm not mistaken, he may have interviewed James Brown. That's where that name comes into play. I'll take a look at that, but if you're telling me, James is a good person to talk to, I'll talk to anybody. I talked to an attorney named Andrew Sendler today. We were kind of going back and forth about some things on the listserv, and I said, you want to come on the live stream? He's coming on at the end of the month. He does a lot of speaking at seminars, does some teaching. He's got a YouTube channel. His videos are typically, hour long, where he'll go through all the things about a hearing, and he'll talk about that more when he's on. They're a different approach than me, but my goal is to share information. So he's going to come in and share what he knows. But if St. Louis, you're telling me that James Brown is somebody that I could talk to, I'll be happy to talk to him. Okay. The Dreamers Club. I turned 55 1 month after my hearing, which was last week. A little scared my health. I think you asked this last week. And what Spencer said, and I agree with him, is that they could hold the case until you turn 55 and issue the decision after that. So they could just hold it open, just wait on issuing a decision. That could happen. It's certainly possible. So there's nothing that stops them from doing that. Thank you. Yes, we send our clients a little note. Happy birthday. In fact, I've got on my calendar, When I, am interacting with my clients directly doing hearing prep, I'll create a contact for them I have a couple of different email addresses. SSD answers 123 is what I use to interact with my clients mostly, but I'll put in the contact their birthday and it pops up. And then we have in our system, it's called HONA we have in the system a feature where it'll trigger us to send out a birthday wish. So we like to do that just because people like to be remembered. Why not? Okay, Golfer Pro. My wife's attorney in New York City wants her to get a written narrative you pay for from 3 of our doctors attesting to condition. Do you usually require a written narrative from your client's doctor? I don't require it. I mean, if I can get one, that's great. It does help sort of translate the medical findings into work limitations. So if you can get it done for 50 or $100, it's probably money well spent. Functional capacity form, same sort of things. So it may not be necessary, but if it's something that the lawyer feels could make your case go from 65% likely to approve to 85%, it's probably money well spent. Unfortunately, the margins in this practice area are just not great enough where, we can lay out money on these things. I wish we could. I know my wife, her practice is workers' comp, and they have a different system where case costs, at the time of settlement, the case costs can be put into the final stipulation, and she gets reimbursed by the insurance company. Social Security doesn't do that. So if I laid out $300, $400, $500, there's no way for me to get it back from Social Security. I have to get my client to get it back. And, I'll just be honest with you, people don't pay it. So we just have gotten to the point where we just don't, I may lay out 15 or $20 for medical records, but I'm not going to lay out hundreds of dollars for narratives or forms. Just can't afford to do that because it's contingency and it's capped. So, we tell our clients, if you want to do it, because they would have to pay for it anyway. If it was any other type of law, it's case cost. Go ahead and send it in. But I would give my opinion as to whether I thought it was necessary. So let's see here. All right, just made a note to myself. It reminded me of something I wanted to deal with tomorrow. Jason, hello, Jason. Hope you're doing well. Ms. B, can one get denied for SSI and SSDI for the same reason, like SGA? Can one still be approved for SSDI if denied for SSI? Yes, because SSI is a means-tested program. And so if you have assets, let's say, you have stocks worth $10,000, that would disqualify you non-medically from SSI, but it wouldn't affect it at all in SSDI. So certainly non-medical things like assets or income could disqualify you non-medically from SSI, but not affect you at all for SSDI. When it comes to the medical side, the standard is exactly the same. The inability to engage in substantial gainful activity due to a medically determinable condition that has lasted or expected to last 12 consecutive months or result in death. So the medical definition is the same, but the non-medical is different. SSI is much more restrictive, but you can qualify for SSDI if you're denied SSI because of non-medical reasons. My husband's income, I don't qualify for SSI, automatically disqualified. No. SSDI does not care about your husband's income. SSI does. That's called the deeming rules. So SSI is a means-tested program for low-income people. And if you have assets or income that exceed these very, very low, they haven't been changed in years. That's a real something else. And again, I don't get on my soapbox here, but they need to change these rules. I mean, it's 15, 20 years, and they still $2,000 is your asset limit. I mean, come on, it's ridiculous. But if you don't qualify for SSI because your husband's income, SSDI does not care about that at all. Let's see here. Let's see for sure. Last time to the doc. Okay, so Russell was basically saying that he has a recent MRI that shows significant problems. The last time he's a single dad and is struggling working at a gas station and doesn't really have the ability to stop working or to go to the doctor, pay for it. So 3 years ago, he had a shoulder surgery, 7 different surgeries in the last 10 years, MRI. This year, a lot of narrowing the spinal herniated disc and 80% of the back. Okay. Now, again, now you're changing the things a little bit, which makes your case stronger. So you don't have recent medical, which is, I still think, problematic, but you got a long history. And, a judge is going to look at this and say, I can assume by your testimony that having 7 surgeries in 10 years, there's going to be scar tissue formation. You're going to have long-term effects of that. So now you have more of a medical history, nothing recent. It's still problematic, but not as problematic as it would be if you didn't have this long history and all you had was the MRI from the emergency room. I still think that a gap of treatment or lack of treatment is a problem, not as much maybe as I thought before I knew this part of it. I don't know if that answers your question, but it is still problematic. And again, for me, I'm looking at cases where I don't want the judge, you're depending on the judge to make assumptions. I don't like to do that. Is the judge going to assume that because you've had, surgery 7 years ago that you're going to have all the scar tissue? That's a reasonable assumption, but it doesn't mean the judge is going to make it. Nice. I'm not sure what tip you're saying nice about, but okay. So nice back at you. I don't know. Okay. Gun lover. Explain how subsidies work for SGA dispute, saved me from an overpayment situation. I was able to get reinstated. Not sure what you are meaning by subsidies forms. I don't know what that means, but you can maybe give me a little more detail. I can answer that. Okay, so you're one of the people that emailed me with the right answer. So yeah, it was a great interview, and you got to listen to Spencer go into more detail. I think his book is like $9. It's not very much. So if you go on Amazon and look up, let me see if I can do it real quick, and I'll show you what it looks like here. Spencer Bishan's. Here we go, $9.99. Okay, and that's for the Kindle version. Paperback's $13. So let me just go ahead and put this up here so you can see it. We're not talking about a lot of money. So it is, share screen. Okay, here we go. All right, so he's selling it for $10 on the Kindle, and I typically buy books on Kindle. I've got an old iPad. I just buy it on Kindle. That one I'll have to physically lug it around. So for $10, if you want it in paperback, it's $13.60. We're not talking about a huge investment. So you're getting, from a guy who worked for Social Security, a lot of insider information. Not a bad deal. Not a bad deal at all. And so again, I don't get any money from this. So I'm just telling you, I think it's a pretty good resource to have. And, if you look at the reviews, he's got 33 reviews. Most of them are pretty strong. So I think it's worth definitely taking a look at. Okay. Kim. Okay. All right. So you talked to Madeline, and Madeline's kind of on summer break right now. So right now, the person who's sort of doing what she did it's either Darlene or Angela. So Kim, I'm going to make a note for someone to call you. I got to get a new form here. So we got Kim, we got Shauna. Okay. All right. So I'll make sure somebody calls you, but if you do call in, you can ask for either Darlene or Angela, and they'll look at Madeline's notes. And Madeline may be back hopefully in a week or two, but she's on summer break. So Kim, you had a stroke in February of 24, so that's a pretty good reason to apply for disability. And they turned you down, which, I mean, what do you say? What do you say? It's crazy. What do you say? It's crazy, but they did. But it is what it is. So we just got to keep appealing it and get you approved. Great question, RD. When you apply for SSA, do you need to worry about social media? Yeah, I think that anything out there is fair game, and I've seen situations. I remember I had why this sticks with me. I don't know. This is probably 7-8 years ago. I had a client who was claiming disability based on back injury, and I always look at their Facebook page. I'll put their name in Google just to see. Facebook page comes up, picture of her climbing a climbing wall, and I don't know when it was, but I called her up and I said, "Miss so-and-so, what the heck is this?" "Oh, that was 7 years ago." I said, "Put your profile in private because somebody's going to see that and it's going to kill your case." So, I would tell you, stay off social media, put your Facebook, your Twitter, your Instagram, put it on private, disable it. Don't put anything else up there until this is all over. And remember, Spencer, we talked about this last week as well. There are nosy neighbors out there. There are people who take it upon themselves to, try to get people, in trouble. And, you may have a mental health condition, you may have a underlying medical problem that's not apparent, and your across the street neighbor sees that and they resent you. They think everybody filing for Social Security is faking it, and they find out you're on disability and they send a letter to Social Security saying, "Joe Smith, that guy's faking it." And it causes an inquiry. So, I just think that the more of a low profile you got, the better. I think that would be, that's my advice. Okay, so I mentioned Elizabeth Warren. She's a Massachusetts senator. What if you're not on pain meds, but are on medication that works like a pain med, but it's not only prescribed for pain? Rarely doctors can't do a prescriber for pain. Again, you're going to have to explain why this medication is being used in lieu of pain meds. And by the way, not wanting to get, addicted, concern about being addicted, concern about being terribly constipated. These are all legitimate reasons not to take pain medications. But if you have a doctor that will basically state, "I put Russell on, this medication because it does reduce pain or it does, help him function," that's really all you need. And, because judges are not doctors. So if your doctor says, "I put him on Ozempic," let's just come up with something, or "I put him on, you know, I don't know, think of another drug that's not pain medication. I put him on Lasix, and it has the effect of reducing his level of pain." That's all you really would need. Okay, after being approved, how long should I wait before looking for a job that will fall into the approved dollar threshold? I would wait till you start getting your payments. That way, you don't do anything that's going to create any red flags. But I think as soon as you start getting payments, if you want to go try to find some work, just do so, but just keep track of your earnings and make sure you understand the trial work period and understand, most importantly, SGA. And as long as you keep your own records, keep a spreadsheet of your own records month by month based on the date you received your income. Ronaldo Productions. A local disability attorney is better to just get started filing for disability and engage an attorney after denial for appeal work. Depends. I mean, some people, I've had people reach out to me and say, "I don't want to mess with this whole thing. You do it. You file the application, you help me with the forms, just do it all." Other people are like, "You know what, I can file." And I tell people, I'm very transparent. You want to file your own application? Go for it. 35% of claims were approved. Maybe you get lucky. Here's a lot of resources out here. Look at all of my websites. Here's some other people's videos. Here's my videos. Give it a shot. If you feel you're able to fill out the form and you got a pretty good argument, go for it. I'd rather you get the money, quite frankly. And even though, look, when I get a case approved early on, a lot of times, and it used to be 4 or 5 months, there was no payment because it was on the private waiting period. Now, if it's taking 8 or 9 months, there may be 3 or 4 months of past due benefits. If the person's benefits $1,500, we may be talking about $3,000-4,000. They're paying me $1,000. A lot of money. I'd rather you keep that. So if you can do it on your own, go for it. I don't have a problem with that at all. And then hire an attorney after you're denied. But if you don't want to mess with all this stuff and you feel like you're concerned that you're going to say something wrong or you just don't want to get involved in it, that's fine too. I'd say unless you've got a really, really severe problem, you're probably going to get denied anyway. But give it a shot. And by the way, if you have a severe, you've got stage 4 cancer or something like that, believe it or not, even though you think, okay, this case should be approved right away, I've had those cases denied. And I will sometimes take those cases knowing I'm not going to get paid. This is kind of we call it pro bono work in the legal business, where I'll file a case knowing it's going to get approved quickly, and I ask for it to be approved quickly. I'm not getting paid, but the person needs it. So most of my colleagues will do the same thing. So believe it or not, sometimes the strongest cases are the ones where an attorney can be the most helpful to make sure it's done right. I remember I had a case a number of years ago, a fellow that I grew up with. I literally knew this guy from the time I was in kindergarten, and he developed lung cancer. He was a smoker, developed lung cancer, and he had been working and just kept working and working. And finally, he calls me up one day. He's like, "I just can't do it anymore. I need to apply for disability," because we had talked about it. And so I filed this application. I put together a statement on the listing. And it got approved at initial. It took about 8 or 9 months. So I did getting paid a little bit on it. But, it wasn't very much money. And I just said to him, I said, look, you can do this on your own. He's like, you know what? I don't want to mess with it. I got it. I'm focused on trying to get better, and you take care of it. Just do it. And I said, well, look, I got, this is what I do for a living. We don't get paid a whole lot of money for this case. And a case like this going to get approved early, because I don't care. He goes, I don't want the stress of dealing with it. Like, okay. We got him approved. I think he lived another year, and then he passed away. And, but he got a, decent bit of money while he was, struggling with the chemo and all that kind of stuff. His wife had a little bit of money, and, he, at least he felt, he didn't have the stress of financial ruin over his head while he was going through all this. And his wife, I talked to her afterwards, and she's like, he was at peace. He didn't feel like he really was, leaving me really behind the 8 ball. And that's, those situations, that's the best you can do. Mr. P, what if you hear voices that make you feel a lot of distress when you're working, causes depression or feeling miserable? Extremely bad case of voices denied and reapplying as well. That sounds almost like a schizophrenic type of thing. Hallucinations are really, really difficult to work past because, the medications that can control them are typically really, really powerful and, can have really severe side effects. And people who legitimately hear voices, very distracting. And if the judge believes that, there's a good chance you win. But what they're going to expect to see is treatment with a psychiatrist, a diagnosis like schizophrenia, and that you've been tried on multiple medications that have not helped quell the voices. So that's what you're going to be looking to do. But yeah, if the judge buys it, you've got a good argument. Sam, I am. My cousin just applied. 64, starting Social Security retirement at 62, has several conditions that make her retire early. What are her chances? Very good. I think that anybody who's 64, you're well into the grid rule territory. You've got multiple medical issues. There's the bias, and realize Social Security looks at somebody who's 64 and says, how could this person start a new career? Probably not going to be able to start a new career. So if you can just prove you can't go back to past work, probably going to win. So I think it's a really strong case. Thank you, sir. Go Braves. Shub and I have got an ongoing thing. He's a Cardinal fan, I'm a Brave fan. The Braves have been sinking lately. They really not doing too well. It's surprising because they've got a good team. There just seems to be a chemistry issue. And we've got a really good GM, this guy, Alex Anthropoulos, who's been really good in the past at kind of finding players off the scrap heap. But the injury bug, I think all 4 of their starters are on injury reserve, and their hitters aren't hitting. So I expect to see the Braves do a lot of wheeling and dealing this winter offseason. And we'll see a new club in the spring. I think Anthropoulos is a really good GM. And, I think also the manager, Brian Snitker, who's been a good manager, been a lifelong Brave for 50 years. Their talk is he's going to probably resign. Maybe his voice is just not resonating with the players. It's just going to be they just need to kind of retool. And this is what happens in, professional sports sometimes. So, Shub, hopefully next year I'll be able to say the Braves are really doing it. We shall see. I have a 10-year gap in work history, only working the past 3 years, recent diagnosis of genetic disorder, also cancer. I think, Marcy, the problem is you may not be insured for disability. So I would get your My Social Security statement, ssa.gov/my account, and see how close you are. You may need to work at least another year, year and a half to get enough credits. And it may not be possible, but I don't know that 3 years, if you haven't worked in 10 years and you only got 3 years of work, probably not going to be qualified for SSDI. So look at your statement, and you can figure out how much more you need to get insured. You got to have 20 credits. And so if they tell you you've got 16 credits, you need 4 more, or you've got 12, you need 8 more, whatever it would be, you got to figure out how to get those credits. Sam Ames says, okay, you're very welcome for the help. You had your hearing. Hopefully you get approved. I think that is, look, I mean, that's why, and yeah, in fact, I had this conversation with a client today. The idea of applying for disability is really, really hard. You're basically saying, you're slapping a label on yourself. Oops, sorry about that. I am disabled. And nobody wants to do that. If you've worked your whole life, you've supported yourself, your family, and now you're basically saying to the world, I can't work anymore, I'm disabled. That is really, really hard to do. And I think that anybody who files for disability, the system judges ought to respect you for that. And I try to point this out in my videos, that you need to talk to the judge and let the judge know this, that you hate the idea of pursuing disability, no matter how old you are. It's not something that people relish doing, but I think judges pick up on people who've given up. So you don't want to be that person. But like I said, I was talking to a client today about this. It's just, you go with the attitude, I don't want to be here. I'd much rather be working. But if you can't work, you can't work. But pardon me, you're not on trial. You did nothing wrong. Sorry about the yawning. Like I said, I played 2 hours of tennis before, and hadn't played. It's been raining here, so I hadn't played in a few days. So, bore me out a little bit. Okay, Russell says, a little behind. Video, what was the thought would be a person on the right amount of pain medication because of the law, can't get the right amount of medication. I think what you're getting at is that, pain medication can be a struggle because many doctors are very concerned about overprescribing narcotic pain medication. And what Russell's saying is they'd rather cut on you than do the other treatment like physical therapy or put you on long-term pain management. And this is, again, where you have to talk to your doctors and get a sense of what the doctors want to do. I don't think you can generalize, but, I do think that doctors are reluctant to prescribe long-term pain management because of the issue with addiction and people abusing these things. And so if you can find something that's non-narcotic, non-addictive, that will control your pain, even if it's being used off-label, that's okay. And I think you need to make sure the doctor explains that. But if you have made a decision, you're not undergoing surgery, and you choose to go long-term pain management, you may have to jump through some hoops to get a long-term pain management doctor who will work with you. Okay. Mr. Lawyer Ginsberg, big pardon. You have to call Mr. Jonathan, and no, that's why I'm here. You have to ask for a pardon. Confused for disability benefits, can turn retirement at 65. No interview, automatic. When you hit full retirement age, your disability becomes retirement. Automatic. My pleasure. I have fun with this. I enjoy talking to people. I enjoy sharing what I know. This is interactive. I've been sort of toying with the idea. I know Walter Knott will have a phone number where people will get on the phone and he'll play them asking questions. I'd thought about that, but if you listen to some of his stuff, people tend to kind of ramble on a little bit. So I haven't ever done that. There is a utility out there where you can call it, It's called what is it called? It's on my podcast website, which, by the way, I haven't really done much with the podcast. I'll just tell everybody about it. So if you want to test it out, you can. It's called SpeakPipe. SpeakPipe. And in fact, I'll show you where it looks like here. If anybody's interested in doing this, you can go ahead because I get notified. If you go over here to SpeakPipe and you click on this, you can record a message and it comes to me by email. So if you have a question that you want me to address in the live stream, leave me a question on SpeakPipe and I'll play it, if you're okay with that, on the next live stream and answer it. And maybe we'll try that and see if anybody wants to do that. If they want to, have their question done verbally, I can play it for you as opposed to just doing the chat, because I know sometimes typing can be a bit of an issue. But if you want to try it, go to ssdradio.com and SpeakPipe and leave me a message, and I'll play it on a question if you've got. I can play that, or you could, of course, it's really easy to do now. Just leave a voice message. Just go online and record yourself, with your phone, and it could be a video or it could be an audio, and just record a question and just email it to me. SSD answers 1, 2, 3. I can put that on there. So I'm open to any of that stuff. I just want to make it as easy as possible. And again, I know when Walter has people calling in, I know he has a problem with somebody wants to give their life story, and he's trying to get through these things very quickly, and he'll interrupt them, and I don't know, it just never really seemed to work as well. So maybe doing it non-live, either by sending me a video or using something like SpeakPipe, would be something. And tell me if you want to do that. If you do, then we can do that. Okay, I've heard you mention before you can see if your clients are approved before they get notified, how that works. Okay, I use a utility, a little program called Chronicle, just like it sounds. And there's a young man that I met at a convention who put this thing together. And what it does is it pulls data from the official Social Security, my login from ERE, and it will update me with the status. So every morning or several times in a day, and I can't show it to you because it's got my clients' names on it, but it will pull from Chronicle that the case have an approval or a less likely denial, and then I see right away. So I don't have to wait for it to come in the mail. So when I see it, I can immediately go to that file from Chronicle and I can download the decision. And so I download it, read it to make sure that it's accurate. I put in my system why it was approved. If it was a grid rule case or whatever, I send my client a email with a copy of it. I ask for a review. In fact, I'll put this on here before we go because I usually do this. But I like reviews are really something really helps me grow my practice. So I'll ask for a review, and I send it to them. And so they'll get it in the mail maybe 3 or 4 days later, but I'll get it to them. And sometimes I literally will come down in real time, and I'll see it come down, and 10 minutes later, my client knows. There's no way that doesn't send me a beep or anything like that. I just look at it, but that's how that works. Does an IRA count for SSI? I believe it does. Yes. SSD subsidies form 3033. I don't know anything about that. Let me just make a note of that. Subsidies 3033. I'll see what I can find out and we can talk about it next week. I just don't know anything about that. Okay. Mary had 3 CEs, and we're getting close to about another 10 minutes or so, by the way. All 3 said you can't work, letters from all your doctors. You still got denied. Did you get denied at a hearing or administrative level? I have no explanation. Makes no sense. You get to a hearing, it's going to be harder for a judge to get past that. The only thing I can think is that the administration, SSA at the administrative level said you could return to your past work. There was no evidence you couldn't do that. But again, you saying it says you can't work at all, I think it's just the wording of what it says, but I can't explain it. There's no good explanation for it. Canova Henry, I have 3 injuries from my lower back in 22 and last year fractured my right knee in July this year at the hospital. You know, from an appeal reconsideration, what is the chance of me winning? You know, you've got a lot of stuff going on. I think not terribly bad. I mean, there's a lot of stuff going on here. I can see how back injuries, bad knee, blood in the brain is going to make it really hard to be very reliable at a job. So I think it sounds pretty good to me. Sounds good to me. Okay. Christy says, is a good idea, okay, for someone who's applying for disability to go traveling. I think that the risk is that if you get in front of a judge and the judge says, they do sometimes, not always, what's the furthest you've traveled in the last year or last 2 years? And if you say, well, I took a flight to Costa Rica, it was a 4-hour flight to Costa Rica, and I was, sightseeing there, is that consistent with a serious back injury? So they're not saying you can't go on vacation, but, it depends on what you do. Now, I had a client one time whose adult daughter took her to France for her birthday. And my client testified that being on the plane for 7 or 8 hours was such that when she got to France, she was in bed for a week and didn't get to do any sightseeing. The judge may believe it, may not believe it. So it's a risk. It's a risk. I'm not going to tell somebody not to go on vacation, but it's a risk. So that's all I can tell you. It's just one of these things you have to be, document what you do, what you can't do. If you need special accommodations, a wheelchair, a walker, yet you're only seeing things from a bus, that's a lot different than walking around Rome for 5 or 6 hours and touring the Colosseum and walking. And, it just depends on what you did, but the judge might ask what you did. Okay, good. That's what I want to hear, Christy. That's what I want to hear. That's the questions you're going to get. There shouldn't be a surprise. And, you want to make sure you answer them ahead of time so you know how to answer them. Silver Monster. When at the ALJ stage, how far out will the hearing be from the time you're notified of the date? It'll be on the notice, but usually you get about 2 months notice. I think there's I think it's, if I'm not mistaken, it's 90 days is I don't know. Honestly, don't know. But I think normally I'm seeing 2-3 months out. Maybe it's 90 days. I don't know. Honestly, I don't know. I don't pay attention to that. I mean, once I get the hearing notice, things go into action, but I'm not involved in it until the case is worked up. And I'm looking at most of my hearing notices. And let's see, let me look at one here. I got a hearing coming up next week. And let's see when the hearing notice was issued. Maybe this will give us a little bit of an idea. Where is the hearing notice? Notice of hearing. Okay. So hearing notice, the hearing is going to be next week, which is August. It says August 13th. The notice was sent out on May 8th. So if that gives you an idea, May, June, July. So it's about 3 months. That sounds about right. That's pretty much what I normally see. Russell says, what happens if you're on Social Security retirement, but working part-time, but something happened to make you disabled? Well, if you're getting full retirement, you can't get any more. If you're on early retirement, you can ask for Social Security disability. You can pursue it and then get the difference between the two. Okay. Short Sweet, 65, reverse shoulder replacement, fusion surgery, 2 weeks applied, being treated currently for emergency notices. Will the grid will apply, be off work for a year? Yes. Assuming no transferable skills, yes. Okay. When you get access to my files, is it reasonable go over so we can get something submitted this time there? Yes, it is. People all the time email me and say, send me a copy of what they got. It's a 2-minute thing. I just go in and copy what they've got, the docket, send it to them and say, tell me what's missing. And, sometimes we do it by phone, sometimes by email. I usually send it to them so they have it in front of them. But yeah, that's pretty common. I mean, Jen does that all the time. I do it sometimes too. It's just that's always helpful to get that information. Somebody at OHO, that's the hearing office, remove all objective medical evidence, submit the rest as a file. How officially object to it and demand the evidence inclusion? Only thing I'm wondering is this older evidence? And if it was, they may decide that it's, let's say you had an MRI from 2010, but you worked up until 2022. They may have decided that the 2010 MRI, even though it's objective, is too old. So I think I would want to know why they, what the reasons, what was removed, and try to figure out why. And you could certainly, if you have an attorney, you can have your attorney resubmit it or ask that it be added back to the file. But there needs to be relevant. If it's something, I will tell you, Social Security looks at it and says, if this is evidence that was from 10 or 15 years ago, and the person worked for 15 years thereafter, how much value is it going to really add here, other than to show a history? That's the issue. That's going to be the issue. Dreamers says, thank you. You're very welcome. You're very welcome. Okay, we're going to take 2 more questions here. One is going to be from New York the Best. 44 years denied since 2018 of lumbar radiculopathy, fibro, severe sleep apnea, asthma, migraines. And I'm going to see SSI doctors, even though I saw one last year at ALJ. The concern I got in New York is, it sounds like you're applying over and over and over again. I wouldn't rely on Social Security doctors to win your case. You need to have your own medical doctors and objective evidence. And, you're denied since 2018. Now we're 7 years, 6-7 years. What has changed? First of all, you're still insured. That's a big question. If you're not insured anymore, that creates a whole nother set of issues. But obviously you keep getting denied. What's the reason for it? And it just may be that you need more evidence or stronger evidence, or you're going to be better off when you're 50, because 44 is still considered a younger individual. Okay, Magdi, last question, because we're now at 2 hours and 2 minutes. I have 4 herniated discs in my cervical spine, 2 in my thoracic spine, 3 in my lumbar spine. I have a hearing a month from now. What do you think? Again, you don't win because you have herniated discs, but I think that anybody with that many herniated discs, it's reasonable to assume they're going to have symptoms. And so if the judge feels like, and again, how severe is the herniation? Is it causing spinal cord compression? My point is simply that a judge, if you've got this amount of objective evidence and you testify, I have severe pain, I have pain radiating to my arms, to my legs, I have severe pain, I'm on long-term pain management, I've been referred to surgery, I think it's reasonable for a judge to say that a high level of pain, a work preclusive level of pain, is consistent with this level of damage to your spine. So I think all in all, it's probably a pretty good case. Okay, I know I got a couple more questions. This one here, I'll just put this in here. I appreciate it. Asha left me a 5-star rating. Great, thank you very much. Highly recommended. Okay, I'd like to involve on board to go to my website and submit a suite. Thank you. I appreciate that very much. Yes, if you go and leave me a review, that would be really, really helpful on Google, on Avo, any place. I've had some on Nextdoor. I've had some on, Yelp. I've had them on all kind of different places, but any place that you could find, if you're so inclined, leave me a nice review. If you find these videos helpful, the live stream is helpful, that would be really, really appreciated, because it does help me grow my practice. And this is I like to share what I know, and this allows me to do it. So I really appreciate that very much. So, all right, we are done for tonight. Thanks to everybody who's joined me. I will see you next week, and we will resume our conversation. If I get a guest for next week, I'll bring somebody on. If not, it'll be me. But again, check out the SSD radio if you want to leave me an audio message. Send me a video if you want to do that way. We'll try some of that, break it up a little bit. So anyway, for now, this is it. Thanks a lot. We'll see you next week. Bye-bye.